side, it's much after passing the value of the pattern that you have now. Nakita ko lang kasi na merong mga columns and so yung iba hindi nakikita yung nagsulat ko dito sa bagay. Ano rin naman yung dahil yung iba ang nasa taas ng malayo hindi mabasa na yung aking sinusulat dito. Okay. We started with eminent domain last time, and we said that eminent domain is the power of the state to take private property devoted to save the public use upon payment of tax compensation. We said that eminent domain is vested in the legislature, but Congress can delegate the power to the President, to administrative bodies, to local government units, and even to private enterprises performing public services. Then we spoke yesterday of the case of Bartillon versus Barangay Masili of Calamba, Laguna, which reiterated the principle that original exclusive jurisdiction over expropriation cases or eminent domain cases is vested in the RTC. Then look at Canoreco, Camarines Norte Electric Cooperative Court of Appeals, which is authority for the principle that the grant of the power of eminent domain carries with it the lesser power of easement of the right of way. Alright. Then we said there are six basic requisites for the valid exercise of the power of eminent domain, at least in general. We will take up in a little while the special instances provided by the Constitution and by statute for eminent domain. For now, we have the six basic requisites. First, necessity. The question of necessity goes into the question of whether or not the taking or the expropriation should take place, taking into account the property to be taken, the purpose for which it will be devoted, taking into account circumstances like the availability of any other property for the same public use to which is sought to be accomplished, or whether or not the property is, or there are other properties cheaper, perhaps more ideal for the purpose intended. All these are supposed to go into the question of necessity. And the rule is, it is within the competence of the courts, to determine the question of necessity for the expropriation. In the case of Republic versus La Orden de Padres Benedictinos in Pilipinas, an attempt was made by the government to expropriate what is part of San Beda College for the purpose of constructing an extension of Claro M. Recto all the way to there used to be a rotonda in the meeting point, the meeting point between Ramon Magsaysay Boulevard, Ligarda, Nagtaan, and Forbes. The trial court apparently failed to determine the question of necessity. And so, when the case was appealed to the Supreme Court remanded the case and said the court failed to consider the question of the necessity for the expropriation. In any event, that attempt at expropriation did not succeed. Now, that is your principle. However, class, whenever it is Congress that directs the expropriation, then the courts are without any power to determine the question of necessity. It partakes then of a political question. The determination by Congress, for example, of the specific property that is to be expropriated for a given public use will bind the courts, and the courts will no longer inquire into the question of necessity. Siguro, kasi, example would be, halimbawa, this is the main highway, this is a big barangay, and the local government officials decide that there should be constructed a high school in the barangay, inasmuch as children of the high school age have to hike 3 kilometers all the way to the high school found in the poblacion. And so, the Department of Education requires them to provide a school site, a 1-hectare school site. The officials of the municipality say, let us try to get a property very near the barangay or in the barangay itself. And they attempt to buy. They offer to buy, but nobody would sell. And so assume that the property owners are A, B, C, D, E, F, G, H, I, and J. So sabi ng mayor, ay kung ayaw nila magbenta, let us expropriate. And the members of the Sangguniang agreed, sige, expropriate. Alin ang ating expropriate na property? Eh, siyempre yung PC. Yan ang katapat na katapat. Yan ang dapat natin expropriate. Sabi ni Mayor, teka, nakakalimutan yung kapatid ni Governor yan. Pakagalitan tayo ng Governor. O, tangin na, hindi tayo pwede niyan. Okay, sige. Sige, huwag na yan. Itong kid B kaya, okay, D. Mas malapit kid B property. O, teka, sabi nung konsihal na isa, si D, girlfriend ni congressman yan. Hindi tayo pwede niyan. Okay. Itong kid B na lang kaya. Kid B, pwede pa rin yan. Tatawid lang ang mga bata at lalakad ng konti. Sabi ng isang konsihal, teka, Mayor, kalimutan mo, malaki ang inambag yan sa campaign expenses natin. Hindi na magbibigay ng kontribusyon yan. Kung kaya yung itong si J, itong tirahin natin, ito lagi natin kalaban eh. Tirahin ka natin yan. Yan ang tirahin natin. Okay. Now, given those facts, the question may be asked, can J raise the issue of necessity in the expropriation case pending in court? In all probability, yes. Yes. There are other properties nearer which would serve the purpose better. Perhaps there are properties cheaper. Perhaps here there may have to be need to ask for an easement of a right-of-way. And perhaps other problems could arise. And so that situation would call precisely for the intervention by the court and the determination by the court on the issue of necessity. The second requisite is that the property taken must be private property. Private property. Private is the modifier. It modifies property. That means the property is privately owned. Because if it were publicly owned, there would be no need for expropriation. Now, what kind of property may be expropriated? Any and all kinds of property. Real, personal, movable, immovable, tangible, intangible, consumable, non-consumable property. In fact, in the case of Republic, parenthesis, government telephone system versus PLDT, the Supreme Court said that the services required by the Republic, by the government telephone system, from the PLDT to allow interfacing, interconnection between the government telephone system and the PLDT fell within the context of property as understood in eminent domain. Services are property within the context of eminent domain. That is what the Supreme Court said. Then, of course, the one other issue would be that which was resolved by the Supreme Court in the case of City of Manila versus Chinese community. In City of Manila versus Chinese community, the City of Manila wanted to construct an extension of Rizal Avenue all the way to Caloocan. This would provide easy access from Manila to Caloocan. They decided on expropriating the Chinese cemetery, or a part of the Chinese cemetery. The Chinese community, of course, resisted and said this is property that is already devoted to public use. Accordingly, the Chinese community did not want the expropriation to take place. So the issue that the Supreme Court had to resolve was, can private property already devoted to public use still be subject to expropriation? The Supreme Court said the City of Manila cannot expropriate this property that was already devoted to public use because the City of Manila was merely acting under a general grant of authority. A delegate of Congress cannot therefore expropriate private property already devoted to public use if that delegate acts merely pursuant to a general grant of authority. The general grant of authority was contained in the charter of the City of Manila. All right. Converse to that class is the statement that if it is Congress that directs the appropriation, then Congress can expropriate even if the private property is already devoted to public use. Or Congress could by law grant the delegate a specific authority to expropriate the particular property desired, even if that particular property is already devoted to public use. Maganda ang desisyon ng Supreme Court yan, matagal na yun na. Kaya respeto natin ang resting place, about dear ones, etc., etc. Ganyan, maganda yung kanilang ano. While sometimes the dead must yield to the demands of the living, nonetheless the living must consider respect for those. And the Supreme Court said in that case, also perhaps on the issue of necessity, that there were other property owners near the Chinese cemetery, offering precisely their respective property as the site for the new street connecting Rizal Avenue to Caloocan City. Alam niyo bakit nag-o-offer yung mga yon? Dahil pag doon dumaan ang street, ang Rizal Avenue extension, lalaki ang appreciate ang market value ng kanilang lupa doon. So yun. That was taken into consideration even by the Supreme Court in that case. Finally, the statement we earlier made, any and all private property may be expropriated, except money. Money cannot be expropriated because just compensation is paid in money. So it will simply be an exchange of money for money. I submit, however, that when we speak of money, which is not subject to expropriation, that money must refer to money which is legal tender in the Philippines at the time of the expropriation. Why? Kasi that is what just compensation will consist of. Money that is legal tender in the Philippines at the time of the expropriation. If it is money, for example, consisting of gold doubloons belonging to the Spanish crown, minted in 1500 or 1600, and the Philippine government initiates expropriation proceedings because they need this for the museum as historical tokens, relics of an age that had long passed, then perhaps even if those gold doubloons may be considered money, they could be expropriated because they are not money which is legal tender in the Philippines at the time of the expropriation. The other property is that is not subject to expropriation is a property right. Choses in action. These are supposed to be causes of action which, because of their because of the uncertainty of prevailing in such an action, cannot be expropriated because no pecuniary estimate can be made. No reasonable pecuniary estimate can be made of that cause of action. Choses in action. Alright. Third, there must be taking in the constitutional sense. Taking. Okay. Class, the correct interpretation of taking today is whenever the governmental act deprives a person, the owner of the property, of the beneficial use and enjoyment of the property. You have, of course, read in your books the ruling of the Supreme Court in the case of Republic versus Castelvi, where the Supreme Court enumerated 5 requisites for there to be valid entry or valid taking. That entry is made into the property, the entry is not for a momentary period only, the property, the entry is made under color of authority, under a writ legal order, or at least under color of authority. The property they entered will be devoted to public use or otherwise informally appropriated or injured. And number 5, that the use to which the property is devoted will deprive the owner of the beneficial use and enjoyment of the property. That's all right, class. But I would like to call your attention to National Power Corporation versus Gutierrez. In National Power Corporation versus Gutierrez, the National Power Corporation, in pursuit of the electrification program of government, of course, tried to bring electric power to remote areas. And so, anong ginawa nila? They put up posts. And over the posts, of course, high-tension wires that will convey the electric current to wherever. Under the owners of the land under the wire demanded payment of just compensation. Sabi ng NPC, National Power, hindi naman namin kinukuha yung property mo. You continue to have title over the property. Kami naman, we are willing to pay. But do not ask us to pay the market value of the property. We are willing to pay only for an easement of the right of way. The case went all the way up to the Supreme Court. And the Supreme Court said, National Power Corporation must pay just compensation for the land under those wires. Hindi bali yung land na where the poles were erected, no? Yun, talagang deprived na, wala na. But yung wire, yung land dito, dahil nasa taas naman ng wires, yung nasa ilalim ng wires, and the Supreme Court said, dapat bayaran pa rin yan. That should be paid. Okay. Why? The Supreme Court said, because you virtually, perpetually deprive the owner of the beneficial use of that property. First, you cannot plant anything that will grow beyond 3 meters because any plant or tree that goes beyond 3 meters would hit the wires. Second, the Supreme Court said, under those wires, there is continuing danger to life and limb if any of these wires should break, and there are people underneath who may be hit by the high-tension wires. They would be fried. And ganon. So the Supreme Court said, wala nang gamit yung property sa owner. Hindi na magagamit ng owner. Kaya you are depriving the owner of the use of the property forever, virtually. So you should pay the owner just compensation. That is, I think, the new view of taking. In fact, sa Amerika, matagal na ito yung case ng isang malaking businessman. He owned the biggest poultry farm in that state. He was supplying supermarkets with eggs and chicken meat. Eggs primarily. Daily nagsusupply siya sa mga supermarkets. Okay. The government did not enter the property. Wala. The government simply constructed an airport in the airport near the farm. When the airport was completed and it became operational, what happened? The take-off and landing of jet planes, the sonic boom somehow affected the chicken. They did not lay eggs anymore. They had contracts to supply eggs to the supermarket. He demanded payment for just compensation. On the issue of whether there was taking, the answer of the U.S. Supreme Court was yes. Yes, there was taking. Even if there was no actual physical entry by government into the land, into the property of the owner. Okay. Dito sa atin, kasi those of you who go through Makati, especially if you go from EDSA all the way to Ayala, for example, along EJ Puyat, I am sure that you must have noticed this, but many people may not have noticed. You are facing Pasay City along Buendia or EJ Puyat. You will notice that the buildings on the right do not are limited to 4 stories. Yung 5th story niyan parang konti na lang, parang meron na lang konting structure doon. Yun. This is a condition, a restriction found in the title of the property by the Ayalas nila may-ari niya mga yan kasi restriction yan. Okay. Okay lang yun, restriction. When you buy the land, meron ka ng restriction. That means you bought the land subject to that restriction. Okay lang yun. But suppose there were no restriction and the city of Makati imposes this as a condition. Incidentally, class, why are structures limited to 4 stories in that area? Dito sa left side, hindi. you will notice that dito sa left side, nandito yung DVP, nandito yung Nachura building na napakataas, etc. Pero dito, puro mga 4 stories lang yun. Why? Because the Ayalas knew before they sold these properties that beside, at the back of Buendia, you have Jupiter Street, and then Jupiter Street actually is the first street that abuts a very big and plush subdivision, the Bel Air Village subdivision, Makati. Kaya prevented ang buildings dyan. Kasi pag matataas, pwede kang manood kung anong ginagawa ng mga tao doon sa, ay kung gagamit ka pa ng teleskopyo, pati yung makikita mo kung anong ginagawa nila doon. Of course, yun. Respecting the right of privacy of the homeowners in Bel Air subdivision. But my question is, suppose it were an ordinance passed by the municipality or the city of Makati, would the landowners then have reason to demand payment of compensation because there was taking? In an old case decided in the city of Manila, the Supreme Court said yes, provided only, no, not in the city of Manila. This was pursuant to a municipal ordinance in a municipality where all landowners near the plaza were prohibited from constructing high-rise buildings because that would block the view of the plaza from the highway. Yun. The city of Manila thing has to do with Ayala, Rojas de Ayala here. Plus, ang akin lang gustong i-point out is the principle is that there will be taking. Unless the issuance of such an ordinance can be justified as a valid exercise of the police power. The landowners in front of Malacanang cannot build high-rise buildings there. Tigalawang stories lang ang buildings dito sa JP Laurel, sa Concepcion Aguila ba yun? Yun. But at this time, this is an exercise of the police power. Ano na lang if you are allowed to build a high-rise edifice there and makikita mo yung presidente doon kung ano pwede. Okay. Pag mataas ka na masyado, maliit na ang presidente. Okay. So, anyway, nasa Indonesia na naman si presidente. Nandun na naman sa Indonesia ngayon. So, anyway, she is less popular than Arab daw, sabi ng SWS. Kung itong SWS. Kasalanan ng SWS yan eh. Hindi yun. Okay. Anyway, that's it. Class. Now, ang importante lang doon, na the governmental act or the act of the expropriator, even if there is no intent to expropriate, because the expropriator in those cases, like in the National Power Corporation case, did not file a complaint for eminent domain. The act of the expropriator, government or the private enterprise, must deprive the property owner of the beneficial use and enjoyment of the property. If there is deprivation, then there is taking within the constitutional sense, and therefore there is the corresponding obligation to pay just compensation, except when the taking is done in the exercise of police power. Okay. Number 4, public use. Itong public use, ano na ito? If you are using a book that was published in the 1970s, please do not read public use there anymore, because you'll be told to read Pascual versus Public Works, Department of Public Works and Highways, public use, meaning doon may distinction pa ng public use at public purpose. At medyo pa. Ngayon, iba na. Recent decisions of the Supreme Court said that the concept of public use is a continually evolving concept. In the case of Reyes, National Housing Authority versus Reyes, the Supreme Court said, when you speak of public use as a requirement for eminent domain, you now equate public use with public welfare, public interest, public benefit, public convenience. All that would already justify public use. And so, in Jimenez versus Philippine Export, PESA versus PESA, Philippine Export Processing Zone Authority, the Supreme Court said, as long as the use to which the property is devoted will redound to the benefit of the public, then the requirement of public use is being complied with. Yun na lang, As long as the use to which the property is devoted will redound to the benefit of the public, then the requirement of public use is being complied with. Perhaps the best example of this is heirs of Juancho Ordona versus Reyes. Ano ang property involved dito? Beachfront property. Privately owned. Government wanted to buy. Owner would not sell. Government instituted expropriation proceedings. For what purpose? So that government could lease. I-lease lang ng government yung property to enterprises, big corporations which will construct hotels and develop the property into a world-class beach resort. Di sabi ng owners, aba naman, ano naman to, hindi naman public use yan. World-class beach resort. Kukunti nga lang ang Pilipino na makaka-afford pumasok yan dahil tiyak ng mahal masyado yan. It will cater primarily to tourists. Desisyon ng Supreme Court, public use pa rin yan. Kasi ganito, sabi ng Supreme Court, tingnan niyo ang argument ng Supreme Court. When all these facilities shall have been completed, many tourists will come to the Philippines to visit that resort. When they come to the Philippines, they will be spending dollars. The dollars they spend will strengthen the Philippine economy. When the Philippine economy is strengthened, then the public will be benefited. Therefore, there is public use, sabi ng Supreme Court. And so, dagdag natin doon sa Jimenez. As long as the use to which the property is devoted will redound to the benefit of the public, even if the benefit derived by the public is merely incidental benefit or indirect benefit, nonetheless, the requirement of public use is still complied with. Now, class, Manioska versus Court of Appeals. Manioska versus Court of Appeals, the issue of public use was raised. Here, the government wanted to expropriate the birthplace of Felix Manalo, founder of Iglesia ni Cristo. It would be converted into a historical monument, no, historical site. Kamukha ng birthplace nila Rizal, etc. No? Yun. And so, a challenge was made on whether there is compliance with public use. And of course, there was a second issue raised, the issue of non-establishment clause, the separation of church and state, because this apparently will benefit members of the Iglesia ni Cristo. The Supreme Court said there is no violation sa non-establishment clause, no violation. The fact that the Iglesia ni Cristo members stand to benefit is recognized, but the benefit they will get is merely incidental to the public use for which the property will be devoted. And the Supreme Court said, Felix Manalo has, of course, reached the prestige and a historical figure in Philippine history. Accordingly, making his birthplace a historical site would promote, precisely would be still consistent with public use. In Philspring International versus Court of Appeals, an attempt was made by local government unit to expropriate 5,000 square meters of privately owned land. For what purpose? For the purpose of urban land and housing reform. These 5,000 square meters will be subdivided into small home lots, lalagyan ng mga streets, at lagyan ng sewerage system, etc. And sold to deserving inhabitants at a very low cost. Ang issue na ni-raise ng Philspring dito sa public use, sinabi, this is too small a property, 5,000 square meters lang. Halimbawa na lang, 50 square meters lang ang isang home lot, isang lote. Maglalagay pa ng streets, etc. Ilan lang? Only, how many? Less than 100 families will be benefited. Kaya walang public use. Sabi ng Supreme Court, the size of the property is immaterial. It is the use to which the property will be devoted that actually fulfills this, since this will be subdivided to small home lots and sold to homeless inhabitants, deserving inhabitants, then public use is complied with. Although, of course, in Philspring International, the Supreme Court ultimately denied the expropriation on some other ground we will discuss later when we go to Republic Act 7279. Okay. Pero doon sa public use issue, public use. Now, class, yesterday we also said that there is a grant of the power to expropriate by Congress to local government units found in Section 19 of the Local Government Code. Under Section 19, it is provided that a local government unit may exercise the power of eminent domain for public use or purpose or welfare for the benefit of the poor and the landless. So, hindi lang public use ang nakalagay doon. Public use, public purpose, public welfare for the benefit of the poor and the landless. Expropriation can be undertaken by local government unit pursuant to that authority in Section 19 for any of these purposes. Be that as it may, all of these 5 purposes would still fit within the present interpretation of the Supreme Court that as long as the public is benefited, even if the benefit derived is merely incidental or even indirect benefit, then public use as a requirement of eminent domain is still complied with. Yes, the most important of all the 6 requisites is the 5th, the payment of just compensation. Because even Section 9 of Article 3 says, private property shall not be taken for public use without payment of just compensation. Just compensation. What is just compensation? It is supposed to be the full and fair equivalent of the property taken. It is supposed to be the market value of the property. The Supreme Court many years ago, attempting to define market value, said it is the price at which an owner, a seller, willing to sell but not compelled to sell, will sell his property to a buyer who wants to buy but is not compelled to buy. Okay. Yun. Market value is the basic amount that is to be paid to the property owner. If only a part of the property is taken, then you compute just compensation on the basis of the market value, to which you add consequential damages suffered by the owner, and from which you subtract consequential benefits, if any, are derived by the owner, provided that in no case should consequential benefits exceed consequential damages. If in the computation the benefits exceed consequential damages, then these two cancel each other out, and the property owner will be still paid the market value of the property. In what form is just compensation to be paid? It is to be paid in money, which is legal tender in the Philippines, and in no other, except in the case of land reform. Under the Comprehensive Agrarian Reform Act, which you have mastered, it is provided that payment of just compensation for land taken in agrarian reform cases shall be made partly in money and partly in land bank bonds. The Supreme Court, Justice speaking through Justice Cruz, in that Association of Small Landowners of the Philippines versus Secretary of Agrarian Reform, said this is allowed because agrarian reform is not really an exercise of eminent domain. It is an exercise of the police power, using eminent domain only as an instrument to attain the police objective. Later, much later, when you have finished with the bar exams, maybe you will find time to read Association of Small Landowners of the Philippines. It's a very long decision. Kung nabasa niyo ang libro ni Justice Cruz on constitutional law, yung buong chapter ng police power reproduced doon sa decision na yon. and it begins with Greek mythology. Ganda-ganda ng kanyang pasok. First sentence niya, Antaeus was a giant, son of Mother Earth. He would draw strength from the earth. Whenever any part of his body was in touch with the earth, he would derive strength from there. Hercules fought Antaeus, and every time Hercules slammed Antaeus to the ground, Antaeus rose stronger than before, until Hercules realized the source of Antaeus' strength. And so he lifted Antaeus up and broke him while no part of his body touched the ground. Tapos, pasok na siya Mother Earth. And then the need of man to have a piece of earth, to have a piece of land. Ganun na. Kahit alam niya namang magandang sumulat si Justice Isagani Cruz. Kaya maganda. Pero do not read that now. Read that after the marriage. Sometimes sayang din ang oras doon. Nababasahin niya. Ang importante lang ng punto, land reform is really an exercise of the police power. Yung punto niya doon na this is an extraordinary form of eminent domain because this is really police power. And that is the only reason why the payment of just compensation is allowed, even if the payment is not all in money. In all other cases, class, except in the cases of reform, land reform, and later urban land and housing reform perhaps, just compensation must be paid in money. This is legal tender in the Philippines. Okay. Ang problema lang kasi, kailan naman babayaran? Ang dami ng hindi pa nababayaran ng gobyerno. Kaya mga, so, ganyan na. Okay. But the most important principle to remember on just compensation, this has been asked at least 5 times in the bar exam. The determination of the amount of just compensation is a judicial prerogative. This was first announced in EPSA versus Dulay and reiterated in a number of cases. Panes, Belen. So ano ang ramifications ng principle? The determination of the amount of just compensation to be paid to the property owner is a judicial prerogative. Therefore, any law passed by Congress fixing the amount of just compensation is unconstitutional. It is an encroachment by Congress into a prerogative of the court. Any presidential decree, any determination, any issuance made by the president or any administrative body fixing the amount of just compensation for property taken in eminent domain is unconstitutional because it will be an encroachment by the executive into a judicial prerogative. Yun lang. Yun. Ang ibinigay na sa bar exams, puro problems. Ingat lang kayo doon. Kasi in the 3 cases mentioned, in Vizca, in EPSA versus Dulay, in Vizca, in Belen versus Court of Appeals, puro presidential decrees ni Marcos yun. And in all of these cases, the Supreme Court said, invalid, unconstitutional decrees. Unconstitutional decrees, and because that constituted encroachment in the judicial prerogative. Now, related to that, if you will read the rules of court, there is a provision to the effect that when the court makes a determination of what should be paid to the property owner in eminent domain cases, the court will appoint commissioners. That rule was there even before EPSA versus Dulay. Kaya, after EPSA versus Dulay, sabi ng iba, hindi na ako kailangan. Judge, ako judge, ako ito mag-decide kung magkano, Bakit pa akong papakahirap mag-a-appoint pa ng commissioners? Then, the issue then raised was, in Meralco versus Pineda, if there is a need to appoint commissioners. Can the court refuse to appoint commissioners? After all, it is the judge that is the final word on what the amount should be. The Supreme Court said the judge cannot refuse to appoint commissioners because this is a substantive right to which the property owner is entitled. But the commissioners can only recommend. The judge is free to disregard the recommendation of the commissioners appointed by the court. Okay. Again, market value of the property. What is the reckoning point? The reckoning point. Where the property that is taken is land, since we are all aware that land appreciates in value over time. When I was in the Department of Education, hanggang ngayon, awa ng Diyos, hindi pa rin nasolve yung problema na yun. Property, land. In 1949, yung matandang may-ari, malawak kasi yung property niya. Kinausap ng superintendent, Manong, pwede ba magtatayo tayo ng eskwelahan dyan? Bigyan niyo naman kami ng lote. Klaro! Ilang hektarya ang gusto niyo? Hindi ho. Kunti lang. Okay. So maglagay. Built a schoolhouse built in the property. For one reason or another, no deed of donation over the land was executed. Namatay na yung matanda. Namatay na rin yung superintendente. Mga anak na. Ngayon, mga apo na. Ang mga apo merong TCT over the property. We are the owners of the property. You either pay us by buying the property or pay us rentals or whatever. Sasabihin ng Department of Education, hindi matagal na yung akin na yan that must have been donated. Ay wala namang papel. So anong gagawin? Sasabihin ng Solicitor General, let us expropriate. Okay. We filed the complaint for eminent domain in 2005. The actual taking was in 1945 or 49. At the time of the taking, the property was worth 1 centavo per square meter. Now, it is 2,000 pesos per square meter. Isang hektarya yan. 1, 2, 3, 4, 5. 3, 4, 5. So, if the payment of just compensation will be based on the market value at the time of the taking, the heirs will be entitled to receive 1,000 pesos. If the amount to be paid
is computed on the basis of the market value of the property at the time of the filing of the complaint, 20 million pesos will be paid for that 1 hectare property. Tingnan mo naman na. Okay. Trouble is, under the rules of court, apparently, it is market value of the property at the time of the filing of the complaint. Teka ho muna. Then, the Supreme Court made a number of decisions. Ang decision ng Supreme Court. The amount of just compensation shall be based on the market value of the property at the time of the filing of the complaint unless there was taking years before and the property owner stands to derive undue financial advantage from the fact that the complaint for eminent domain was filed only recently. Yun. And then in 2001, in the case of Islaban versus Leonorio, the Supreme Court said, the determination of the amount of just compensation shall be based on the market value of the property at the time of the filing of the complaint or at the time of the taking, whichever came first. This is the latest decision on the matter. I don't know if this is going to be changed later or whatever. Pero ito, yan ang ano. Whichever comes first. Plus, that is supposed to be the rule in general. When it is a local government unit, undertaking eminent domain, look at Section 19 of the Local Government Code. Payment of just compensation shall be based on the market value of the property at the time of the taking. Basta local government unit taking permit. We have the case, a 2002 or 2003 case decided by the Supreme Court involving the city of Cebu and the spouses de Gamo. In that case, the Supreme Court said ang basis market value at the time of the taking because we apply Section 19 of the Local Government Code since it was the city of Cebu, a local government unit, that undertook the expropriation. Related issues. Yesterday, class, we spoke of the issuance of a writ of possession. Writ of possession. Invariably, ini-issue yan naman. And then, we spoke of whether or not the property owner can also withdraw the money deposited in the bank. And we said, the Supreme Court in Land Bank of the Philippines versus Court of Appeals said yes. The property owner can withdraw. Now, dun sa determination ng market value of the property, mayroon pang isang issue. The use to which the property is currently devoted or is devoted at the time of the expropriation. Kasi ang nangyari nito, ganito. Okay. Itong property na ito, agricultural pa talaga. Agricultural land. Tax declaration, agricultural. Ang deklarasyon, agricultural land, mababa ang hata. Pero, mayroon na dito nag-convert ng kanilang property and subdivision na. Ito converted na, ito residential subdivision na. Ang dito nag-apply na rin for residential, meron na ng subdivision plan. Ganyan. Yung dito, ganun na rin. So, during the trial, was there is a trial na. Kasi kadalasan, the property owner will really insist on his own valuation and try to prove the allegation that the property is worth more than what the expropriator is willing to pay. Okay, so yun. The owner presented evidence na itong mga ito, ang aking mga kalapit na properties, residential na, dapat ang pagbayad sa akin on the basis of residential na rin. Dahil ganun din naman ang gagawin nyo. This will be converted into residential property anyway. You are going to get the subdivision here, low-cost housing, etc. Sabi ng Supreme Court, hindi pa rin. No. It is the use to which the property is devoted at the time of the expropriation that determines, or that is determinative of the market value of the property. Okay. When is payment to be made? Ang sabi ng Supreme Court at a reasonable time. In fact, in Laban versus Leonorio, the Supreme Court said, when we speak of the Constitution providing that the property owner is entitled to just compensation not only means the correct amount, but also payment, prompt payment. And so, if there is a delay, so ang daming delay talaga ng buha. Doon sa amin, merong inexpropriate ang gobyerno kasi nagko-construct ng airport. Awa ng Diyos, hindi pa rin nagagamit yung airport. Hindi pa rin binabayaran ng property. Yun. Hanggang ngayon. This started in 1964, 65 yata. Ayun. 40 years na. Tingnan nyo, ang nakakaawa doon. So, 1965, land values. 30 centavos per square meter. Sabi na DPW. So, sige, payag na kami. I-increase natin yan. Gawin natin piso. Piso per square meter. Ayun. Okay. So, because of the delay, can the property owner demand payment of interest? Yes, according to the Supreme Court. National Power Corporation versus Anga, the Supreme Court said yes, entitled to payment of interest if, of course, the property owner demands interest. But what is the interest rate that may be imputed upon the amount due for payment? Sabi ng Supreme Court, 6% per annum. 6% per annum, because the interest that will be imputed shall be based on the interest for damages, not interest for forbearance and the use of money. Pag-utang, 12%. Pag-expropriation, 6% lang. Yun. Now, although, of course, we speak of the owner being entitled to payment of just compensation clause, remember that anyone who has a valid existing interest in the property taken should also be paid just compensation. A mortgage creditor, si A may-ari ng lupa, naka-mortgage kay B, binanatan ng estate, in-expropriate, si B babayaran, kailangan bayaran naman ng mortgage debt si mortgagor because he has an interest. Anyone who has an interest will be entitled to share, of course, in the payment of just compensation. Then, title over the property. In the instances when the expropriator requests the title be transferred from the property owner to the expropriator, title shall not pass until after payment of just compensation. There is even an old decision of the Supreme Court to the effect that if, even after expropriation proceedings had been commenced, the property owner had still religiously paid on real estate taxes, then he is entitled to a reimbursement or a refund of those real estate taxes paid. Alright, finally class, number 6, due process of law. In the case of Bilen versus Court of Appeals, the Supreme Court said that in all expropriation proceedings, procedural due process should be complied with. And so due process here is really intended for the property owner. He has to be given notice and an opportunity to be heard. To be heard on what? To be heard on his defenses. Yung objections niya, which may be based on any one or on all of these. Or, at the very least, he should be given an opportunity to prove the market value of the property taken. Doon lagi ang laban eh. Doon na lang nagkakainitan sa proving the amount of just compensation. There is no rule in law that the determination of just compensation should also be attended by compassion. Kaya yan. Alright. So again, class. Although I doubt if an examiner will give you an entire problem and then ask you if on the basis of the facts and the problem there is a valid exercise of the power of eminent domain. In most cases, the questions asked have to do with one of each of these specific elements or requisites for valid expropriation. So yun lang. Ang kadalasang just compensation, wag niyong kalimutan yung EPSA versus Gulay. Ngayon pa lang sinasabi ko na yan. Maisa-cite niyo pa yun sa inyong answer. Pag nakita niyo, banatan niyo ang ating case of EPSA versus Gulay. Kung gusto niyo pati yung citation. GR number. Kaya gusto niyo lang ang correct answer mo, baka na ma-examine ang sabihin, magaling ito. Memoryado pati yung case number. Alright. Now, other instances under the Constitution that speak of eminent domain. Section 18 of Article 12. Look at Section 18 of Article 12. The state may, in the interest of national welfare or defense. Hindi na lang basta public use. In the interest of national welfare or defense. Establish and operate vital industries. And upon the payment of just compensation, transfer to public ownership, utilities, and other private enterprises to be operated by government. What are we talking about here? It is the state requiring that certain businesses be transferred to government so that government will operate the business. But what is the purpose for the takeover or the transfer? The purpose is in the interest, in the national welfare or defense. Malawak ito malawak na authority. But while you are looking at Section 18, you may as well also look at Section 17 of Article 12. Note the difference. In times of national emergency, the state may, during the emergency, and subject to such terms as it may prescribe. Temporarily take over and direct the operation of privately owned public utilities and other businesses affected with public interest. Under Section 17, what is granted to the state is an exercise of the police power in times of national emergency, temporary takeover, directing the operation of privately owned public utilities and other businesses affected with the public interest. Yun. Okay. 18, again, is eminent domain. 17 is police power. This is interpreted very well by the Supreme Court in the recent decision in Agan versus Piatco. I am sure that you must have heard of this Piatco case. Incidentally, Agan and the other petitioners here are concessionaires ng terminal, ng airport terminal. When they went to court to contest the Piatco contract, etc., and the entitlement of the contractors to operate, Piatco to operate the Terminal 3 that they constructed, they were saying that under the contract, their entitlement to concessions will no longer be respected. And so, on the issue of whether or not they are proper parties, the Supreme Court said proper parties sila, because they stand to lose their livelihood. Therefore, they sustain an injury from this act of government in entering into this contract with Piatco over the operations of the Terminal 3 at the Naiya International Airport. Okay. Dito, in the course of the trial, of course, and in pleadings lahat, sinabi diyan that the government has temporarily taken over Terminal 3. Okay, what did Piatco do? Piatco said, oh, okay, all right, but you should pay us. Pay us. This is a takeover by government. We are entitled to reasonable compensation. Sabi ng Supreme Court, no. You are talking of Section 18. What happened is Section 17. Because of exigent circumstances, government had to take over operations of the terminal. But no, this is temporary takeover lang. Kaya ang discussion ng Supreme Court, even if there is a stipulation in the contract, even if there is a stipulation that the government will pay reasonable rentals or yes, for this, the Supreme Court said, no stipulation can overcome the exercise of the police power. The police power prevails over contracts. And note, sabi ng Supreme Court, that the takeover is not a takeover of ownership. It is a takeover of operation. And it is temporary takeover of operations, not of ownership. Maganda na after Agan, we are more or less clarified with the working of Section 17 and Section 18. Alright. Then, class, before we break, let us finish this. Then, Article 13. Sections 4 and 9. Section 4, Agrarian Reform. Association of Small Landowners of the Philippines on the constitutionality of the Comprehensive Agrarian Reform Law. We have a recent case on Santa Rosa Realty regarding the constitutionality of the retention limits. Yung retention limits naman ay isang issue dyan. Right. And you have discussed this already. You have finished mastering this. Dito tayo sa urban land and housing reform. Urban land and housing reform. We, in implementation of the policy enunciated by the Supreme Court, rather enunciated in Section 9 of Article 13, the Congress passed the Republic Act 7279. This is known as the Urban Development and Housing Act of 1992. UDHA. This law has been criticized by many. Sino yun? Neil Cruz, columnist sa Inquirer. Whenever talagang mainit siya dito sa Republic Act 7279. Mainit siya. At galit na galit siya kay Senator Lina, kay Joey Lina. Dahil si Lina ang author, this is also known as the Lina Law. Kaya whenever he writes about this in his column, he says, the stupid Lina Law. I don't know which is stupid, the law or Lina. So anyway, yun. Pero plus, this is the law that also says that you cannot eject squatters without providing them with resettlement and etc. Ito yung, kaya maraming galit dito. Pero there are provisions in this law that authorize local government units ngayon sa urban areas na mag-expropriate para magtayo ng socialized housing diyan sa urban areas, because it is in the urban area where the housing problem is most serious. Ganon naman talaga. So yan. And so we have Philstream International versus Court of Appeals and the more recent decision of the Supreme Court in the case of City of Mandaluyong versus Francisco. City of Mandaluyong reiterates Philstream International. Pero mas maigi kasi may dagdag ang City of Mandaluyong. In both cases, the local government units failed to expropriate. Mainly because under the law, there is a priority listing of properties that may be taken for socialized housing. Number 1, government lands. Number 2, alienable lands of the public domain. Number 3, idle, unregistered or abandoned land. Number 4, lands that have been determined already as sites for government projects, areas for priority development, zonal improvement program, Islam improvement and resettlement program, but had not yet been acquired by government. Identified na site for this, but hindi pa kinuha ng gobyerno. Number 5, bliss sites. Identified na rin na bliss site, but hindi pa kinuha ng gobyerno. And finally, number 6, privately owned land. Ang importante lang dito, in both Philstream and City of Mandaluyong, the Supreme Court said, under the law, privately owned lands can be expropriated under this only after proving that you have exhausted all the first 5. No available land classified under the first 5. Then you can expropriate private. privately owned land. In the cases we have mentioned, the local government unit could not prove, did not prove in Philippine, could not prove in Mandaluyong that there were no lands available among the first 5 mentioned below. So that is the first requisite before a privately owned land may be expropriated. The second requisite is that lands belonging to small property owners under the law, lands belonging to small property owners cannot be expropriated under the law. And the law defines a small property owner as one whose land does not exceed 300 square meters in a highly urbanized area and does not exceed 800 square meters in other urban areas. You are still a small property owner if that is all you have, provided of course that you don't have any other land anywhere in the Philippines. So, uli, isipin nyo na ang under Section 9 of Article 13, we are talking this time of urban property. Urban na ito. Hindi ito rural property. That's why it's land reform for agricultural property. And it is urban land and housing reform for properties for lands found in urban areas. Kaya, Urban Development and Housing Act ito. Yan. Okay. With that, we have more or less, we have covered the whole eminent domain. We take a break. We come back and finish. Maybe we'll try to finish. Wala namang, after a discussion of Section 1 of Article 2, madali na yung iba. Hindi na mahaba ang discussion. So, we will try to finish this so that tomorrow we start with the Bill of Rights.
Madali yung goods na yun. Ano yung qualifying range sa last? 300 square meters. Highly organized. 800 square, not more than 300 meters. Highly organized. Not more than 800 meters. Other urban areas. May qualifying doon na. Paano kung may last table? Sinabi niya talaga. Provided or pwede naman sigurong ano eh. Anywhere in the Philippines talaga or on that particular city or ano na lang.
Anywhere in the